It's a little crazy with the kid and the dog.
I can't get my video to work today.
That makes me look adventurous.
Oh, sorry.
Oh.
I know. Oh no.
Welcome to Bankruptcy. Oh, so bad.
That was the worst thing ever. That was so bad.
Hi, everybody. I'm hoping everyone can hear me all right. And so far, so good. I'm not getting any messages saying that you can't hear me. So, hi, welcome or welcome back to another session for our Bankruptcy Week. In this section, we're going to be going over Bankruptcy Basics with Ron Drescher. Very excited. My name is Spencer. I'm a customer support specialist at Next Chapter. I have emceed before. The last time was for a summer camp for the annual talent show, and that was for about 300 children. For this one, it looks like we have about 875 or so legal professionals, so it's basically the same thing. So let's move on. I'm going to pull up the slide here for this session. Oh, great. We've reached the limit of live attendees. All right. Once again, welcome to Bankruptcy Basics with Ron Drescher. Before we get started, I did want to go over a couple of slides that we have here. These are just our housekeeping notes. You may have seen these in the last session. We have the chat on the right-hand side here, and we just wanted to have that available so that you can chat with your fellow attendees, communicate any technical issues that you might have. Also, we will have a Q&A, so if you have any questions for the speaker, you can actually ask those in the question tab. And there should be a poll available provided by Ron. So, going into our code of conduct one more time, we just want to make sure that everyone's using inclusive language in the chat. Once again, we're using it as a tool. And we want to make sure there's no threats or intimidation, obviously, and no offensive comments. We're really excited to have Ron with us, so be nice. I'd like to go into some of our stats as well. So since the pandemic started, obviously we're looking at a lot of changes headed our way, which is really why we were looking into creating this conference. For instance, unfortunately, there's about 3 million people who might not have the means, so are not paying their mortgage. In addition to that, about 1 in 4 small businesses have shut down. I think the last number that I received was about 24%. Also, about 22 million people have filed for unemployment, as well as, and then we did note that during the last recession, bankruptcy filings were up about 74%. So you'll probably hear this term thrown around a lot. They're expecting a tsunami of bankruptcies. So because we are a software company in the bankruptcy field, we do have a lot of firsthand experience, and that is once again what led us to creating this conference with a lot of really experienced and skilled speakers. And that brings me to the speaker who I would like to introduce. We have Ronald J. Drescher, Esquire, and Ron has been the managing attorney at Drescher and Associates, PA, He's been practicing since Back to the Future was in theaters. That's 1985, if you weren't prepared for a movie trivia today. Ron is experienced in filing bankruptcy cases, as well as posting bankruptcy videos on his YouTube channel. Ron is the author of numerous articles and books and has over 150 five-star reviews on Avvo and Google. Avvo? I forgot to look up the pronunciation. And a fun fact about Ron, as I invite him to the stage, on his bio, he mentioned that he loves gadgets, golf, and good fried chicken. I like my phone, I like to putt-putt, and I order Raising Cane's from Uber Eats. So we are not that different, Ron. And I will just be inviting you to the stage. We're going to give it a couple of minutes. Love technology. I'm sure if we were in a live crowd, we would have a roaring applause right now.
Hello, hi. Can I be heard?
I can hear you. Were you able to hear me that whole time?
I heard everything you said, and I got my Uber Eats on the way.
That is so important to me. I was afraid that I just gave you that incredible introduction and no one could hear me. So I'm going to get off the stage and I'm going to let you take it away.
All right. Thank you so much. I'm very excited to be here. I really want to thank Next Chapter for putting this together. And I just we're going to get started right away. And bear with me just 1 minute while I bring up my presentation show. All right. So the name of this course is Bankruptcy Basics. And but what I really want to do is not just say, oh, this is the automatic stay and these are preferences and this is a petition. That's in the glossary that I have linked to in the chat box, and I just linked to it again. So feel free to look at that, and if you really feel like you want to get that foundation about like what is the automatic stay. I'm gonna assume that everybody kind of knows what that is, and if not, it's going to be in that glossary so you can refer to it. And what this presentation is really designed to do is give you an idea while you're sitting with the client or the prospective client, and you're thinking about, you know, how do I help this person? What are the questions that you should be asking yourself before you move forward? So these are the 3 questions every bankruptcy lawyer needs to ask. And so the first question is, when do we file this bankruptcy? And the question isn't why not what chapter, because in your mind, you already have an idea kind of what chapter is going to be the right fit for that client. But I'm more interested in saying, well, when do we file this case? Do we need to file it like yesterday, or do we need to wait to file it? And I do find that a lot of attorneys aren't so focused on the timing considerations of when to file the case. So, all right, depending upon where you practice, you're going to see more or less high income clients. And these are clients that might be stuck in Chapter 13 because they are above the median. I'm seeing in this chat that some people can't see all the slides. So here, let me see if I can go full screen, because it's more important that you see my slides than you see me. And I don't know if that helps, but I just gave it a shot. So one of the things we always want to do is, if a client can qualify for Chapter 7, which is the quick, easy, least expensive, you know, the fastest opportunity for you to get that discharge relief, can we get him into a 7, or are we going to be stuck with a 13? So if we've got a client that just gets a regular pay stub, no bonuses, nothing interesting, nothing unusual, then this isn't so applicable. But you're going to have a lot of clients that have seasonal income or get a big year-end bonus. So you need to keep in mind that when you are dealing with a high-income client, and that's a client whose income is over the median for their state and family size, what you want to do is look at the last 6 full months before you file to see whether or not they are an above median or a below median debtor. So if you file on May 1st, you count all of April and the 5 months preceding. If you file on May 31st, you count April and all of the 5 months preceding. You don't count May until you file on June 1st. So if you have a seasonal employee, or let's say a real estate agent or some other commission-based person, and they tend to have a better time of year than another time of year, you may want to delay the filing so that the last trailing full 6 months will drive them below median. Because what they do is they take the last full 6 months gross income and they double it. So you want to look at those last 6 months, and you may look and say, well, you know what, I really should put this filing off till August and September because they have a very busy winter. Or if they had a really busy October or November or December, then you want to wait until those 6 months, that's 6 months behind you. So to me, that's a very important consideration, because whenever I have a client that looks like they're heading for Chapter 13, I always try to hit that home run and see if I can get them into a Chapter 7. All right, now foreclosures. Certainly, you're going to want to try to beat the foreclosure sale. Client calls you, they're facing a foreclosure. You need to calendar that date and make sure you file that case before the foreclosure sale, because under most state laws, you aren't going to be able to redeem that mortgage after the hammer falls at a foreclosure. So that's really pretty basic. But you know what? There's another way to look at this. Let's say you have a client, and this is actually fairly common. You have a fair number of clients who have a decent paying job, let's say as an accountant or an attorney or a doctor, and then they file this, they go into a business that fails. And a lot of their debt are guaranteed leases and vendor payments, etc. So you want them to go into a Chapter 7 because it's non-consumer debt, and they don't look at non-consumer debt. If you have a client whose primary debt, and that we're talking about 51% of all their debt is non-consumer debt, then they're going to qualify for Chapter 7 even if they are a high income debtor. That's a huge backdoor to Chapter 7 that you should always look at when you're analyzing a client situation. But a big problem you have is that a lot of these higher income debtors that have failed businesses, let's say they'll have $250,000 in business debt, but they may have a $500,000 mortgage. And that mortgage will dwarf the business debt and will disqualify them from a Chapter 7. Well, okay, sometimes these clients can't afford to maintain their home for whatever reason, and they're going to surrender the home and maybe go through a divorce and really may have an entire bankruptcy meltdown. So I see somebody says, this seems a few steps ahead for a basic lesson for those with no bankruptcy experience. And you know what? I get that, and that's why I gave you that glossary. But if you have no bankruptcy experience and you're sitting down with a client, you're going to have to know how to manage that client's situation. So what I'm trying to do is bring in some basic concepts in a more real life context. And I hope that that's helpful. And if it's not, I certainly apologize, but I do believe that if you pay attention to what's going on and read the glossary, this will all become understandable. So you have this client that is melting down. So you may want to wait until after the foreclosure sale of that home so that their mortgage debt will decline. And then you'll be able to get them into a Chapter 7. And I've put off bankruptcies for months and even years waiting for all that to happen. Another thing is, homeowners association dues are dischargeable in bankruptcy, but after the bankruptcy, you can't discharge those homeowners association dues as long as, there's more videos. I tried to click out. You can click out of the more videos. All right. So,
Sorry.
all right, we're going to have to go forward. All right, I apologize for this. I'm trying to. All right, so homeowners association dues are dischargeable in bankruptcy, but they are not dischargeable after the bankruptcy until you're out of title. So you may have a situation where a client still owns their property after the bankruptcy, and homeowners association dues are accruing. And so you're going to need, the video slide is blocking the pre. Let me try something else. Let me see something here. All right. So this should work. All right. So until your debtor is out of title, those homeowners association dues are going to continue to accrue. So you need to be mindful of that in timing your bankruptcy. One of the kind of clients that you're going to get are clients whose income is being garnished. In fact, clients all the time are in a situation where they put it off to the last minute. They think they can solve their problem, but then their wages get garnished, and they have to come see you. So when that happens, one of the hidden benefits to bankruptcy is that you can recover funds that are garnished from your clients during the 90 days before the bankruptcy. But I have the elements there. It's got to be an involuntary transfer. The funds need to be exempted in the bankruptcy. The trustee has to not seek to recover them, and the trustee won't bother if they're exempted. And the transfers have to exceed $600 over the prior 90-day period. So you're going to have a client that's going to come to you and have no money to pay you. And let me tell you something. Bankruptcy is not like criminal law. In criminal law, and I know we have some criminal lawyers in the group, if you say, look, my fee is $5,000, they're going to find the $5,000 because the urgency is so high. Bankruptcy is not like that. They're not going to call every single person that they've ever known to come up with your fee. It's not that kind of a practice. So you're going to have to be a little creative in how you get paid. So one of the best ways to get paid is when you have a client that has had their wages garnished during the 90 days before bankruptcy. As long as it's over $600, you can get that money back during the bankruptcy. And, you know, the creditors who have garnished that money, the lawyers are pretty sophisticated. They know that that's happening. A lot of them hold them in their escrow account for 90 days to make sure that this doesn't happen. And you'll get that money back like 99% of the time without having to file a lawsuit. And you can have your client assign that money to you as part of your fee. But you can't get any of that money back if it's less than $600. And so you do want to time it sometimes so that they've garnished more than $600 during the prior 90 days. Now, so another situation is that there are some times when, and this is especially important in Chapter 11, which is way beyond the scope of what we're doing, but where there's been a transfer prior to the bankruptcy, and you want to be able to recover that transfer. So you need to set your calendar for 90 days after that transfer. Make sure that bankruptcy case gets filed. That's another timing element to make sure that you can recover whatever that transfer was. In my case, as you could see from the slide, there was a bonding company for a failed construction firm, and they took a long time filing their financing statement. And so we had to file the bankruptcy to set that aside, and we brought millions of dollars in for the benefit of creditors. On the other hand, you're going to have a client that transferred money or property before they came in to see you. And that happens a lot. Clients play lawyer all the time, and they get scared, and so they'll transfer something to their sister or their child or their wife right before they come to see you. And you'll discover that. Sometimes you don't discover that in the initial consult. You won't discover that until you go through all of the documentation they give you. So when they've transferred something during the year before the bankruptcy, they will not get a discharge, which is capital punishment for bankruptcy. So if they have done that transfer, you're going to have to wait for the year until after they made that transfer before you can file the bankruptcy. Otherwise, they won't get a discharge. Similarly, there are 2-year rules, which is for federal fraudulent conveyances. And a fraudulent conveyance is when you transfer an asset without getting fair consideration. It's something that our clients do because they're scared or because they don't want to lose these assets. When you do that, under most state laws, there's at least a 3-year look-back period for creditors or a bankruptcy trustee to recover that asset or those transferred monies. Now, a lot of states have a 4-year look-back rule, and there are even some states where there's no statute of limitations. Although I think those are very rare. Maryland is a 3-year rule. So sometimes what happens is a client will come to you and say, well, I've got these assets that I need to protect, and they can't protect them in bankruptcy. So what they frequently do is they'll transfer them to somebody they trust, and then you have to wait 3 years before you can file the bankruptcy. And this also comes up all the time. A big time consideration happens when you have repeat filers. And while some people swear that they're going to file this case once and be done, many, many, many times you have clients that need to file again. And there's the 2468 rule. And the 2-year rule is if you previously filed a Chapter 13 case where you get a discharge, you can file a second Chapter 13 case after 2 years. And by the way, this time runs from the petition date, does not run from the discharge date. Discharge date's not relevant. Honestly, I think the 2-year rule is odd. It never comes up because the Chapter 13 case typically requires a 3 to 5 year time before you can get your discharge. So only if there is a hardship discharge would this come into play. I've never seen it. You're probably not going to see it. The 4-year rule comes into play a lot. That's where a client has filed a case in Chapter 7, gotten a discharge, but then they got themselves into trouble afterwards. And because they've got themselves into trouble afterwards, they need bankruptcy again. You can put them into a Chapter 13 case, do a 3-year plan where you have the lowest possible payment, and then you can get them some relief. There's the 6-year rule, which also I've never seen. If you previously filed a Chapter 13 case and got a discharge, then after 6 years, you can file a Chapter 7 case. Again, I've never seen that. I think most people, after they go through the nightmare and the hardship of a Chapter 13, they've learned their lesson, and I think that they've done better budgeting. I've never seen the 6-year rule come up. And then there's the 8-year rule, which is the most common, which is if you previously filed a Chapter 7 case, then after 8 years, you can file another Chapter 7 case. And what that means is you may have a client that comes in after 6.5 or 7 years, and then you need to know, can you file another case? And then you give them 2 options. I can file a Chapter 13 for you now, or we can wait a year and we can file a Chapter 7 for you. And most clients, I think, will choose the year. They'll wait the year. And you can help them try to hold off creditors during that year. I've had a lot of success with that. All right, now, over and over and over again, you are going to hear that income taxes are not dischargeable in bankruptcy. And that's just not true. You can discharge income taxes in bankruptcy. Now, discharge is the injunction that the Bankruptcy Code gives a debtor that prevents creditors from collecting on account of debts that are discharged in bankruptcy. And if you ever have a client question whether or not a particular debt is dischargeable in bankruptcy, just go to Section 523A of the Bankruptcy Code. If it's not listed in Section 523A, it's dischargeable. That's your basic rule. So sometimes clients think that medical debts aren't dischargeable. Say, no, not in 523A, it's dischargeable. So discharge of income taxes. You're going to have a lot of clients that are going to come to you and they're going to owe taxes. And you're going to need to know when you talk to them whether or not you can discharge their income taxes. I think that's pretty basic. Can you discharge income taxes in bankruptcy? The answer is yes, but there are 3 critical timing elements. The first is that it's 3 years after the returns first become due. So how does that work? Tax year ends December 31st, 2017. The return first becomes due April 15th, 2018. 3 years after that, after on April 16th, 2021, 2017 taxes are going to become due. Now there's a catch there, which is if you have a client that's been on extension, you extend that out to October 15th. Even if they filed their taxes on May 1st, it's still, because the return isn't first due till October 15th, you have to wait that time. I have lots of lawyers that don't even consider waiting until those taxes will become due, until those taxes will become dischargeable to file their bankruptcy. I think it's really important in a basic bankruptcy course to know that you can discharge income taxes, but that you may sometimes have to wait. It could be worth thousands and thousands of dollars to your clients. The second timing element is that it has to be 2 years after the return is actually filed. So I think that that's another thing. I've had clients come to me for taxes for 2014. They owe $40,000. They haven't filed the return. They just think they're going to owe $40,000. I said, file the return. We'll wait the 2 years. Then we'll file the bankruptcy. That's actually a course of action I've taken many times that clients find very useful. Then there's the timing element, 240 days after assessment. To me, that's hardly comes into play. That's usually only relevant if there's audits or tax court appeals. Just two quick caveats. If there's been a substitute return, that will never be dischargeable. That's when the IRS files a return for your client. You're going to have to get a transcript to do that. And then there's payroll and sales tax obligations. That's when you're a business owner and you're required to withhold taxes from your employee or sales taxes from your customers, and you don't turn them over, then you're going to be accountable for that, and you can't ever discharge those in bankruptcy. So, you know, I want to take this minute. Bankruptcy is a lot more than just sitting down with a client, collecting their pay stubs and their tax returns, and filling out forms. It's way more than that. And you don't, and the most dangerous place to be for a lawyer, and I think this is true in every practice, is where you don't know what you don't know. And so I believe if you're going to take the leap to have clients hire you to do their bankruptcy, that these things that I'm going through now are really the bare minimum that you have to at least know so that you service them properly. All right. Another item that comes up all the time is when you have judgments for possession. A lot of clients are tenants. And if a tenant has a judgment for possession against them, then the automatic stay, which goes into effect as soon as you file the bankruptcy, does not apply. And the landlord can just continue with that eviction. And that's a hard thing for a lot of clients when they hear. It would be great. One of the first questions I ask the client when I sit down with them is, all right, are you rent? Are you current with the rent? If they're behind on the rent, I want to know, has the landlord taken you to court yet? Or is the landlord threatening to take you to court? You need to file the bankruptcy before the judgment for possession hits. Otherwise, the automatic stay won't help and the client will be evicted. There's an exception to the rule, and I'm going to spend 5 seconds on it because it never comes up. But if the client pays the money into court for 1 month's rent and makes arrangements to cure all of the other delinquent rent within 30 days, then the automatic stay will apply. But clients just are never in a position to do it. But you need to know when you're sitting there, if there's a judgment for possession against them, that bankruptcy, and the only reason they're filing bankruptcy is to stop the eviction, that bankruptcy is not going to accomplish that. All right, question 2, where to file? And the reason I bring this up is you don't want to waste time conferring with a prospect who you won't be able to help. So there are venue rules in bankruptcy, and there are basically 4 places: where you live, where you intend to live permanently, your principal place of assets, and the principal place of business. And that generally doesn't apply to where if you have a job and where you go to a job. And you need to find all of these things out right away, because the truth is, if you've got somebody in Ohio, if you're in Ohio and you sit down with a client who has gotten a referral from you, or they're on the phone and they're in Pennsylvania, and they don't have any venue in Ohio, you can't help that client. And really, you should refer that client out immediately. I mean, why should you spend your time and your client's time when you're not going to be able to help them? So it's very important that you identify as soon as possible where you can file the case. And by the way, that's these 180-day rules. We're talking about the greater time during the last 180 days. So that's another timing consideration. You're looking for at least 91 days in any of those places. Now, finally, we get to the question that maybe all of you thought was going to be the first question, which is, what chapter do I file under? You know, so there you're looking at what are the threats that are facing your client. Is it a garnishment? In which case you're almost certainly looking at a Chapter 7, unless there are other problems that come up. Is it a bank seizure? Again, probably a Chapter 7. Is it a foreclosure? Probably a Chapter 13. Is a judgment going to become a lien that's going to impair their assets? Could be a 7 or a 13. It could be what I call imminent doom, which is you'll come and have a client who is current on everything, but they know that in a week or 2 weeks or a month or 2 months, they're not going to be able to keep it together. And they have frequently done, you know, really tragic things like invaded their retirement accounts, which are exempt everywhere, in order to pay credit card bills, just because they just couldn't bear the thought of filing bankruptcy. But now they're facing imminent doom. So these are the things you're most likely to see. You'll need to protect their assets. That's one of the key things. People want to know, am I going to lose my home? Am I going to lose my car? They want to know if they are going to be able to keep their income. And you want to be able to discharge the maximum amount of debt. So Chapter 7. Chapter 7 should be your bias. You should want to put your clients into Chapter 7 if you can. It provides the most relief in the shortest time. Typical no asset Chapter 7 case lasts for like 90 to 100 days. That's the classic fresh start. So, and a lot of people say, well, I want to get into Chapter 7s, but you know, I really don't want to do 13. Or there are some people who are Chapter 13 experts and not so much Chapter 7. And I think you need to learn both, because you have a client that you're trying to help. And sometimes Chapter 7 is the best for them. Sometimes Chapter 13 is the best for them. And sometimes it's kind of a toss-up. You have to give them all the options and let them make the choice. In Chapter 13, I identified 9 reasons why you might file a Chapter 13 case. And one of them is the client just makes too much money, and that's the means test. Another time is the client has too much equity in their assets. And then what you really need to do is you need to buy back the equity from the creditors in Chapter 13. So you're going to have to go through what the creditors would get if the client had filed a Chapter 7. And if the client doesn't want to lose that asset, then you go into a Chapter 13 and make that payment plan over 36 to 60 months. Client has obtained a Chapter 7 discharge in the case filed within the last 8 years. We talked about that. Sometimes the client has a debt that can't be discharged in Chapter 7. For example, tolls. I had a client that had $35,000 in toll violations that would not be dischargeable in Chapter 7, but are dischargeable in Chapter 13. Certain marital property awards that are not domestic support obligations are dischargeable in Chapter 13, but not in Chapter 7. And then sometimes if somebody does an intentional property damage, but it's not personal damage, you can discharge that in Chapter 13, although that's really very rare. What's very common, though, is if you have a piece of property, that is not going to, that has multiple mortgages against it, and the first mortgage is worth more, is higher than the value of the property, you can strip off that second mortgage, which is a phenomenal opportunity in Chapter 13, not something you can do in Chapter 7. One thing in mind, these home mortgages are sacred cows. You cannot restructure a home mortgage that's secured solely by a lien on your personal residence. So you have to really get a valuation of that property. Values are of critical importance in bankruptcy. All right, restructuring car loans is something, your client may have gone into a dealer, traded in their old car that already had negative equity. They rolled that old loan into the new loan, and then they're stuck with an exorbitant car loan. If you wait 910 days, you can reduce that car loan to the clean retail value of the car. And that's a tremendous benefit for Chapter 13. Other rarer things that I've done is sometimes you have a client that's being garnished for private student loans, and that lender will not work out any deal. You can put that client into a Chapter 13 and get a 5-year respite from that garnishment. Now, some clients don't want to do that, but a lot of clients are very happy to apply that 5-year Band-Aid. It's worth knowing. Sometimes the taxing authorities won't agree to a payment plan for whatever reason. I mean, typically, the taxing authorities' payment plans are lower than the plans in Chapter 13. But in Chapter 13, if you could discharge some of your older taxes and are only stuck with some of your newer taxes, you could work out a payment plan on just the newer taxes and discharge the older taxes. That could be a fabulous reason to use Chapter 13. So that's good to know. Then there's Chapter 11. In Chapter 11, which really you should never even talk about in a basic case. It's a highly complex litigation-driven process that's best suited for businesses or individuals with sophisticated finances. Now, sometimes you're going to have a client that will come in and they're over the debt limits, specifically over the debt limits for the secured debt. Now, if you're in the heart of Baltimore City, it's probably not going to come up. But if you're in Los Angeles County, probably comes up all the time. So it's just good to know that there are debt limits in Chapter 13, and sometimes Chapter 11 can be used for those clients. You should also consider some other non-bankruptcy remedies. Sometimes you can defend the lawsuit, and that's worth considering. And sometimes if there are just a couple of creditors, you can negotiate with them. I'm not a big fan of negotiating credit cards because I don't feel like I add value for that. These credit card companies, they've got very rigid guidelines for when they will give relief to the client and do a settlement. And it doesn't matter if it's a lawyer or a client's office. For businesses, you might want to consider a state court receivership instead of a bankruptcy. I've had situations, especially where I'm trying to buy time for the client, where there are, like a bank account has been frozen, and I want to go into the state court and use exemptions to unfreeze the bank account. And I've done that a few times, and that works out very well. There's credit counseling, like Freedom Financial. Typically, people who come to me have already tried those and failed, but they've been around for a long time. They must help some clients. It's a thing to consider as a non-bankruptcy remedy. And then there's creditor blocking, where a client hires you to do a bankruptcy. You're not really sure when or if you'll file that bankruptcy. Depends on how things develop. But you want to be able to talk to that client and talk to their creditors. They want you to field creditor calls, and they'll pay for that. They'll pay you monthly to field creditor calls. so that they don't have to be bothered by them. And that is another opportunity for you to capture fees in a situation that's very hard to capture fees.
Hey, Ron, I didn't mean to interrupt, especially you have a lot of information here. We wanted to leave a little bit of room for Q&A. Did you have a couple of points you wanted to wrap with, or and then we could start a Q&A in about 5 minutes?
Actually, what I wanted to wrap up was, and what I'd like to do is go back into the YouTube, and bear with me, we'll fast forward through this, and I know that it sometimes gets cut off because of the more videos. So, you know, the question is, would your practice benefit from automated communication with clients, automated document collection, trustee meeting reminders, milestones such as no distribution reports, discharge and case closing? Will your practice benefit from practical strategies for analyzing Chapter 7 liquidations, capturing uncertain clients, finding solutions to the difficult cases? These are all things that I cover in the course. You saw the call to action before on the complete bankruptcy course that I'm offering. I offer detailed forms for client service agreements, lien avoidance motions, motions to extend time, you know, other items that come up. I have all sorts of promotional materials for the course. So there's blogs, facts, infographics. These are some infographics that I created when I had too much time on my hands. These are all available for you to rebrand with your own practice and use them in your promotional materials. And I provide some coaching as part of this program. I have 35 years experience. I've got a multi-state practice. I have a method for obtaining client testimonials. And, you know, I know that there are a lot of people who are brand new to the bankruptcy practice. This course that I've decided, Complete Bankruptcy, is really designed for people who want to get in, but really don't have any experience and don't want to have a piecemeal learning curve. So that call to action came up before. If you want to get it, I don't know if it could be sent again, but if all of these materials seem like something that would interest you, I'd be more than happy to talk to you about what's involved. I will call you and explain the program to you personally. So I hope that you'll take me up on this offer, because I do believe that it offers a lot of value. And now I'll be happy to open up everything to questions.
Honestly, I feel like that answers one of our questions. I'm looking at the popular questions here on my phone that was sent through our Slack channel. In fact, I'm going to close out your media here.
Great.
And oh my goodness, there we go. BK. And we went through the effort to put this slide up for the Q&A. Might as well. There it is. Boom. So, okay, first of all, though, I do want to say thank you again for being here with us. I love the presentation, a lot of really, really good information. I know that you were trying to give as much info as you could. But there were a ton of questions for you. This was a very well-attended session. Let me see. For one, it says, for recovering of garnishments, are the first $600 also able to be recovered? Or is it only amounts above the first $600 that can be recovered by the debtor?
Great question. Great question. You can get all of it. If you go to $599, you can't get anything. If you're at $600 above, you get it all.
Let me see. It says, what if under state law, the funds garnished are not exempt?
Okay, fair question. Most states have what is called a wildcard exemption. In in which case you could fit it into there. Look, some exemptions, some states are very generous in their exemptions, and some states are very pecunious in their exemptions. And that is a state by state question that I just can't answer right now. But you should look to the wildcard exemption to see if there's room, and there might not be room.
Okay. Let me see. This says, if you could recommend hold on one second. It says, at some point, can you discuss if you recommend parties file bankruptcy before or during a divorce, or whether they should do it post-divorce?
Okay, that's another, I mean, that's a pretty sophisticated question, actually, because that goes to the nature of the assets. All right, I'll say this. If you're in a state that has tenants by the entirety exemption, which is a very broad form of exemption only available to spouses, you should file the bankruptcy before the divorce. It's a very complicated answer. It's a good question, but you should definitely file it before the divorce to clear off those debts.
Okay. This one here says, on the repeat filers, that is from date of filing or from date of discharge for the refilings. That is the date. Oh, so that is the date of the filing or from date to discharge for the refilings?
Date of discharge is irrelevant. You don't look to that at all. It's always filing date to filing date, or what we call petition date to petition date.
This one here says, are taxes dischargeable even if the payer entered into a payment plan with the IRS?
Yes. That's an easy one.
Short and sweet.
Absolutely. Happens all the time. It happens all the time that I'll tell clients, continue with your payment plan, and when the 3 years run out, then you can go ahead and file and discharge them. What you have to be careful about is an offer in compromise pending. That's going to extend the time period.
Phenomenal. And I think we have time for one or two more here. This one says, much has changed in the last few years regarding the implementation of electronic filing. Can Ron discuss the practical aspects of and procedures for electronic filing?
The short answer is every court has an attorney manual, and a help desk. Now, on the other hand, I have procedures in place. One of them is using Next Chapter. I went to Next Chapter 3 years ago because I wanted to have a complete cloud-based solution. And Next Chapter is fantastic. And I'm not just saying this because they invited me to speak to all of you, but really it's a wonderful cloud-based solution. And I've been extremely happy with it. And it fits hand in glove with the ability to manage a bankruptcy practice remotely or from anywhere on earth if you have the right software, which includes the right cloud-based solution.
Yeah, I appreciate the plug, man. All right, so we did have this question that was basically, do you have recommendations for more resources, education on basics of bankruptcy, which you went through. You had mentioned your course. It looks like we had a question here is, how much is the complete course?
You know what? There are a lot of different modules. I believe the course will pay for itself within a month or two of your practice. But there are different choices, and so I would just as soon have that private conversation with the people who are interested.
Okay. I think that's the majority of them. We are running short on time here, so I thought it'd be a good time to wrap it up. Once again, I hope you can imagine the applause. We really do appreciate your time. It was a very informative session. At this time, I was also going to mention one that that you will be presenting again this week. I want to say it's on Friday, but I might have to double check the schedule The part of the schedule that I have up now is for the fireside chat on the future of law with Ed Walters. And that will be taking place today at 4 o'clock Eastern. And I'm just checking my notes here. I want to make sure I don't forget anything. Thank you to everyone who joined. This was a huge session. I know that we actually hit capacity at one point, but the materials will be made available for everybody.
Oh, good.
Yes, yeah, and once again, in case I didn't mention it before, thank you so much again, and we really appreciate you being here today.
Thank you. It was great, and it's important now. I think the world is going to need more bankruptcy lawyers, and I look forward to working with you guys again.
Thank you so much. I'm actually going to go ahead and end the stream here. I think we're ending about 4 minutes early, so make the best of your time.
I can answer more questions if you'd like.
So I pulled the ones that we had that were I think that were highest upvoted. I want to make sure I didn't miss any. We have the recommendations. I think we went through the most popular ones. I'm going to look over here and see if we have any new ones.
Someone asked if my course cover material from a creditor's point, and it doesn't. It is designed for debtors. But there's a bankruptcy mastermind that is exclusive to the people who take the course. And during that, of course, everything's fair game. And I represent creditors in bankruptcy, and I'd be happy to help out anybody who wants to join the course and participate in the mastermind. Certainly.
This one here that just came through was, can you point us to resources regarding student loan debt and bankruptcy issues?
I covered that briefly in my course. It's very hard. Student loans, really hard. There are in the chat, somebody wants to address COVID-19 impacts, please. And I would love to, but we don't, nobody knows. Nobody knows. First of all, obviously it's going to, I believe that they might change the bankruptcy code based upon COVID. And I think depending upon what happens in the next election, that might impact it. I don't want to get into politics at all, but that's going to be a factor. A lot of the states are extending forbearance and of evictions and foreclosures, but that's going to end, and that's going to end at different times in different states. So I'm not really sure. I would love to address that, but it's tricky.
This one here is, how and what do we advise clients when it comes to alternatives to bankruptcy?
Sometimes there is no solution. I've got a client paying me $150 a month for the rest of his life, just to capture until the statute of limitations runs out, and then they don't need bankruptcy. That is a solution that most lawyers won't even talk to you about. They'll just say, I can't help you, and leave. But it's a solution.
Okay. If we have time for one more, let me see. If someone has assets too high for Chapter 13, how can those assets be reduced so they do not have to face Chapter 11? Wow,
can't answer that question here because everybody's situation is different. If it's cash, that's one thing. If it's real estate, it's another thing. If it's personal property, it's another thing. And sometimes there is just no answer. Sometimes you have to give the client the least bad outcome.
Okay. And it looks like we have last two things here. The one was just Why did you choose? Oh, but I'd rather have Janine hop in.
Somebody called the cops. Somebody called the cops on them. The party
Surprise
must be
cameo.
over.
And then they said Janine's going to be on. I'm like, oh, do I do this first? There you are. Okay.
Yeah, no, this is a surprise cameo here. Yeah, Ron, I just wanted to thank you so much for all of this. Everybody, I mean, so many people are so excited about this session, and they wanted to get in that we actually went over capacity, and we had hundreds of people emailing us asking for more. So I was wondering if you'd want to do a follow-up on maybe Thursday. We have an available slot perhaps. So maybe we could even do a little bit more and another follow-up, and answer some of these questions.
Are you talking about in the afternoon?
Yeah.
Let's do it.
All right, cool. Well, we'll
Absolutely,
get in touch with you. And we will take all these other questions and be like, try to put them, maybe it could be more of a question. You can even invite some people on stage if you'd like. So, and it could be more of a conversation like this. So we'll get in touch. I thought I'd just come on and surprise question you here. But
all right, that sounds great. Yeah, I mean, like I said, Thursday I would love to sit and do Q&A for an hour on for
all
your group.
Yeah. So yeah, we'll do, we have it'll be more of a bonus session. So you've got this one, anything you were unable to cover, and anything that we see that's like a lot more questions about, in this session. So cool. Well, I think we're probably at our limit now. So thank you so much, Ron, and everybody who joined us. And
my pleasure. Thank you.
And I think the slides, the glossary, the information about your course, and all of the session recording, all of that will be available after the session. So
wonderful.
Great. Thank you. And
all right. Thank you, Janine.
Thank you, everyone. Take care.
Take care, all. Be safe.